Here is why people in this country who own properties and who understand how the law works are very, very apprehensive in giving out these properties on rent to tenants. A client recently called me up and said that my landlord has filed a civil suit for eviction against me. I am very, very afraid. I need more time to vacate this premises and put my affairs in order and move out to another place. What do I do? And I asked him, how much time do you need? And he said, I need minimum 5 months. And I laughed and I told him, you will get far more time than that. He asked, how is that possible? And I explained to him, this is the process. You have received summons for the case. Once we go to the court and say that there are some documents which are not very, very legible, some documents are missing. The court will direct the plaintiff to supply the entire copy to us, after which the court will grant us some more time to file our written statement. There is statutory period which is available under the Civil Procedure Code. Once we do that, the landlord can move, if they are smart, an application for judgment on admissions. They will file it in the court will issue notice to us, we will again come and seek some time to file our reply. There is no statutory limitation on that. We can take 1 or 2 days to file that reply. Once we then file our reply, the matter will be fixed for arguments on this application for judgment on admissions. We contest it to the best of our ability, and most likely we will lose, and the judge will give a preliminary decree of handing over possession by the tenant defendant to the plaintiff landlord. Now, all of these things will take a minimum, with the fastest, most savage judge, a minimum of 5 to 6 months in any case. So you don't need to worry about, there will be plenty of time. Now, of course, the drawback here is that you will, at the culmination of these proceedings, be liable to pay if the landlord correctly is able to prove the lease documents, and if they don't, you will not be liable to pay a huge chunk of the rent amount either. But assuming that the affairs are in order of the entire transaction between the landlord and the tenant, you will be liable to pay the rent plus, say, somewhere between 6 to 12% per annum as interest. And of course, the client is very happy, but when I have to fight these cases from the side of the landlord, I know what frustration, what pain and suffering the landlord goes through. It is what it is. If we want a little change in the system, which I strongly believe in, we should be doing, there needs to be higher costs. Something called as mean profits needs to be taken more seriously by the courts of law, and I believe to a certain extent involvement by the legislature for harsher impositions must be there. So harsher imposition, the law being brought in by the legislature, then after that the judiciary stepping in and saying we must impose exemplary costs upon a defendant who refuses to vacate the premises once maybe the lease has expired, or if there is breach of the tenancy agreement, or if the notice period is complied with. This should be done. Of course, I am not going to go at all into the law of rent control, which is a completely different monster. Maybe we can deal with that in another occasion. Another one of those social evils that need to be dealt with in this country. Oh, and by the way, the client that I was talking about, his landlord plaintiff, when he filed the case, this was back in March of 2022. When we appeared before the court, the next date which was given was of July 2022 for the mere act of completion of pleadings. So this process will in any case stretch out to at least, I would say, perhaps a year or maybe even more than that. There you go.